voluminous. They're not here yet.
Okay, thank you, Assemblyman Wright, and also thank you, Assemblyman Picardo, for allowing us the opportunity to speak on this important issue for cooperative apartments. I am Barbara Askins from the 125th Street Business Improvement District, but tonight I'm here speaking as a homeowner, a cooperative owner, 1275th Avenue. I purchased my cooperative 18 years ago. 1275th Avenue was built as a cooperative with 202 apartments for middle-income families. It was the first of its kind created in 1959 in Manhattan under Section 213 of Title II of the National Housing Act. Over the years, I have served on the committees and on the board. I have been the treasurer, the vice president, and chair of the Building Systems Committee. It is through my experiences and looking at it from both sides of the fence that I am convinced at this juncture that new legislation is required to protect the rights of shareholders. During my time in the building, shareholders have made several attempts to get help for things that in their estimation was not correct. A written appeal was sent to the Attorney General to look into how funds for capital improvements were being spent simply because the board and management repeatedly refused to respond to any inquiries from shareholders related to the finances, while at the same time costs for improvements continued to escalate above what was presented. This resulted in a response from the AG that basically informed shareholders that the AG could not do anything unless shareholders could provide information related to criminal activity. Copies of the response is attached, of our request to the AG is attached. Providing information is impossible for us because shareholders are not presented with information that's relevant or usable information. Shareholders subsequently hired an attorney to guide them or look into matters of transparency and getting more information about what is going on with the money, only to find out in a situation of us paying for non-productive advice, which was to run for the board. Many members seeking help have served on the board for many years, and serving on the board for life should not be what is required for shareholders to have their rights. Shareholders were forced to hire an attorney to take the board to the court, merely just to get a meeting to discuss how to finance capital improvements in the building. Recently, a few shareholders hired an attorney to review and give legal opinion regarding proposed bylaws drafted by the building's attorney and presented by the board. The response was frightening. It highlighted my appreciation for this meeting and to share what we faced and seek ways that the investment of shareholders are protected. Our attorney wrote, although the majority of the changes in the proposed bylaws do not at a first glance appear to be particularly harmful, when considered together, the cumulative effect of the changes is that the board's power is significantly increased at the expense of the individual members. A particular concern is that, as a whole, the changes create the potential for a small subset of directors to wield considerable power with reduced transparency and accountability, and in some circumstances without recourse from the members. We found issues with transparency, conflicts of interest, board collective power, reduction of shareholders' power, board's members' individual power, management agent, and more. Specific concerns were, as it relates to transparency, the rights of board members. There were recommendations for the rights of board members not to be heard at a meeting. There were reduction of recording requirements, reduction in the required number of signatures, and non-board members having power to bind the cooperative. There were conflicts of interest related to fraudulent proxies, reduction of election oversight, and increased possibility of self-dealing. There was increased board collective power and reduction of shareholders' individual powers, such as removal of specific dates and times for an annual meeting, removal of shareholders' ability to add items to the board agenda, removal of requirements of notice of adjourned meetings, and removal of the minimum quorum. We found in the proposed bylaws there was provisions for increased board members' individual power, such as reduction in the minimum number of required board meetings, allowing as few as 3 directors to conduct business virtually without notifying other directors of specifying purposes of a conference call, allowing one person to hold multiple offices. And more frightening to us, board members put in a provision to be paid for the work that they were elected to do. The managing agent also put in a proposal, where the board would then grant the management agent control over everything except our stock certificates and occupancy agreement. New bylaws that were being proposed eventually would have removed the supermajority requirement for changes. Because of some of us who came together and paid out of our own pocket and then distributed all of this information to the rest of the shareholders, the board attorney and the board withdrew the proposed bylaws for the moment. But it is very clear to us that the lines have been drawn in the sand and the laws are not in our favor. It is clear that shareholders cannot continue to pay additional funds for an outside attorney, pay increases due to improvements without proper financial disclosure, and we cannot serve on the board forever. There is a need for governmental intervention. It was a good thing for government to create cooperative living. It is now time for another good thing to happen, and that is to protect the rights of those who have invested. The managing agent and the attorneys all are paid by shareholders, but representation from them only supports the board of directors. So I ask, where are shareholders to go if the co-op's internal rules as set forth in the bylaws, the proprietary lease, and the certificate of incorporation are not being followed? Where are shareholders to go when the rights to call an extra meeting or special meetings are not being honored? Where are shareholders to go when prudent business judgment and making decisions are not being exercised? Where are shareholders to go when a simple request for minutes are denied and nothing is written in the minutes that relates to any of the decisions that are occurring? Assemblyman, both of you, all of you, the Assembly, we need help. There's a need for new legislation. The new laws do not work anymore. And I cite these as examples because in talking to others, there are some buildings who are not experiencing all of what we are experiencing, but many are experiencing some of these things, and there are more. The existing structure have learned to function in the laws that exist. And those laws do not take care of those of us who are spending the money. And I thank you so much for this hearing.
Thank you.
Oh,
I don't know where you think you're going. Well, I think, Ms. Askins, you've opened up a whole can of worms.
oh, Lord.
You've told a very compelling story. And I'm sure it's not just unique to your development, but as you said, I'm sure some of these problems, and quite frankly, in talking to you and other folks with the same sort of, that's why we are having this hearing tonight. And we wanted to get your story on the record. So I do thank you for testifying this evening. Anything for you, Jeff?
Just simply out of curiosity, where to begin? So just out of curiosity, if I may ask, how much out of pocket did you have to come to pay for an attorney in order to get something as simple as getting the minutes from your board? Just give me a rough estimate. I don't need exact dollars. If you feel comfortable disclosing.
Yeah, well, we didn't pay for the minutes. We paid for the bylaws. Yeah, we paid, you guys, some of you, how much we paid? $9,000?
$9,000?
Yeah, for the bylaws. So we had to raise and collect money from all of our shareholders to do that in order to stop them. Yeah.
I'm just sort of.
We don't have that money. I mean, it's a lot. We struggle to pull it together.
I would imagine. I would imagine. Just very, very quickly, just as an aside, and thinking about this, maybe we'll have a conversation with the chairman and the rest of our colleagues. Is there any recall mechanism? So, for example, there is a recall mechanism, technically.
I don't know what it is.
Yes, there is. You can call a special meeting and remove officers.
We had to go to court to get the last special meeting. They denied it.
In my bylaws,
Yeah.
only the president can call a
Right.
special meeting.
So if the majority of the shareholders recall a special meeting, the president can basically put the kibosh on that, so to speak?
Or not call it, which is what we did before. We had to go to court for like 3 months for the judge to tell him he had to call the meeting.
Okay. I think I appreciate it. Thank you so much for your
Well,
testimony. ma'am.
if I'm not mistaken, Ms. Askins, in the last paragraph of your testimony, you asked the question about 5 times, where are shareholders to go for various
Right.
things concerning their living. Now, ostensibly, isn't the Attorney General, aren't you supposed to go to the New York State Attorney General? Ostensibly, aren't you supposed to go to the Attorney General's office to get relief?
Okay. The Attorney General's office, as I understand it, because I've been really researching this for the last 2 years, is only they're not set up to monitor what's going on with, the operations of the co-op. If you can report criminal activity, then they will come in, but you have to have at least something to get them to walk in the door.
So you're saying there's no place to get relief but for the courts of the state of New York?
And that does not work because the existing laws, the judge may have sympathy for you.
Got it.
Right.
Okay, we got it now, and I thank you for your testimony, and I'm sure Mr. Pichardo and I will be looking for a place where cooperators can get some relief.
Thank you.
All right, thank you.
Thank you, ma'am.
Don't think I didn't hear that. Thank you. Who is this? Ms. Ramona Gray, Edward Sisters.
Good evening, everybody. Good evening, Honorable Keith Wright. As you all know, my name is Ramona Gray Harris, and I'm a property manager with Edward Sisters Realty. We have been in existence for more than 60, 80, 90 years. I am nobody's counting at this moment. I'm a second generation, and I have been working as a property manager in Harlem. I have gone through TILs, I've worked with HDFCs, I've worked with co-ops and condos. I would say I need to go back before I go to talk about affordable housing, first to deal with HDFCs. I know in your last hearing, you received so many numerous problems that I don't even think you were aware of. And I know that HPD has come in to help with the new regulatory agreement, but often what has happened with the new regulatory agreement is it causes more problems than it fixes. The 8A loan that the HPD has put in place is a wonderful program, low income for a lot of money, but they hire the lowest contractor, and we get the lowest work. Right. So we have a number of problems. We have HDFCs are in trouble, trying to pay taxes, trying to pay water, trying to fix the building. They get an 8A loan. The work is done halfway, and they have numerous problems that go on. It's not the way to go. I don't know the answer, but in picking up and working with many of these HDFCs, and I'm dedicated to work, I will put everything I can to make these buildings whole. You've come up with so many problems. HPD can't answer you. Nobody else can give you answers, and you're stuck with trying to figure out how to resolve issues as they come up. One of the biggest issues at this moment, as quietly as kept, is that the people who want to buy in HDFCs can't. There is only one place that's going. Lower East Side is the only place. Citibank and Chase, for all the conversation that they had, will not loan. So people who are trying to pick up these HDFCs and buy them, they have no way. Can an HDFC take back a mortgage? No. Okay? So you have a problem here. You have people who do want to buy. You have people in the buildings who want to sell so that they can be made whole, that they can pay the back taxes, that they can raise the maintenance. It's a give and take situation, all right? And when I come into an HDFC, I have to plot a plan, and it has to be a plan with the shareholders, the board members, the contractors, and everybody that's trying to make this building whole. If you don't have everybody working in the same direction, it does not work. One of the other problems that is coming out is that Harlem now has become the biggest gold mine that there is. Everybody wants to be in Harlem, all right? And in trying to be in Harlem, it has created this issue of everybody trying to get in and take everything that's there, all right? So as a property manager who's been in here forever, I see buildings that have management agents come in, and all they do is rake them over the coals. They never help them. They never work with them. I see contractors coming in doing the exact same thing. It's not a nice story. I don't know how to answer the story, but for the buildings that I pick up and try and work with, I try my damnedest to get there. We take over the buildings that are always in trouble. They don't have budgets. They've been self-managed. They have no professional care. They don't have corporate taxes paid. They're always behind. And HPD comes in and says, I will give you the loan. All right? So we now have a loan for $100,000 to do renovations in a building. Currently, I have a building that has picked up an HA loan. They're trying to work. And every day, we have an inspector from another agency, part of HPD, coming in and giving us another set of violations. Even though we're trying to fix it, it doesn't work. Somehow it doesn't work. I would love to say that all of the HDFCs are affordable. I would love to say that the HDFCs are the way to go for affordability. And I would love you to figure out a way that we can keep them affordable.
No pressure.
None whatsoever. Thank you.
Thank you. Thank you very much.
Do you have questions or?
Just very quickly, again, thank you so much for your testimony. So you mentioned that the large banks refuse or just don't sort of get into this.
No.
Is there any way, well, first of all, why? Just out of curiosity, what's sort of your take on that?
Right now, I would say that Citibank and Chase are not going into the mortgages. In addition, Citibank and Chase, their mortgage sections are in Wyoming and Wisconsin. Mm-hmm. They have no idea of the market in New York. Sure. So they're not loaning. Anybody who right now wants to buy an HDFC cannot get a mortgage from them. Cannot. There's not been one. I have buildings that are fully financially capable of submitting everything, and they still cannot get a mortgage.
I mean, isn't there, at least for them, some sort of financial incentive? I mean, there's got to be. I mean, it's New York.
If you would like to find it for me, I would love to give it to people who want to buy. But right now, Lower East Side is the only place, the only bank that at this moment is loaning.
Is there any way to compel these banks to loan? I mean, we've bailed them out.
It would be a great idea. Mm-hmm. Some pressure needs to be given someplace. Okay. But right now, there's none.
Well, if I may take the liberty, I will ask Chairman Wright and some of our colleagues who chair relevant committees to bring some of these individuals in front of a committee and respectfully request Mr. Wright to work with our colleagues as well to see if we are able to bring some of these individuals and ask them personally and very straightforwardly, why aren't you making these loans and extending
No,
these?
absolutely.
Yeah. I'd appreciate it.
Thank you.
Thank you.
Thank you, Ramona. Thank you. Thank you so much. Coming down to the end here, but I certainly want to go, Yolanda Belcher, is she around? Yolanda Belcher? There we go. Oh, thank you. That was very good, Yolanda.
Good evening, Assembly persons. Glad to be here tonight. I am the owner of shares in a Brooklyn co-op for the last 12 years, and I have to admit, over the majority of the occupancy, there's been a failure to maintain the property. Mold issues, which date back to 2009, are continuing to 2014. Repairs are not done in a timely manner, and they don't maintain common elements. The Tenant Shareholder Association tried to initiate a petition seeking a change or replacement in the management company, and it went nowhere. It's a great location. I like the co-op, but they're not really taking care of the co-op. They do make a lot of mistakes. There needs to be work to be done to correct these mistakes so that they don't happen again. Okay? I'm pleased to be here because there hasn't been really much attention paid to common interest developments, Class 2 cooperatives, and condominium properties. I have to admit the research that I've conducted over the last year of the applicable general business corporation law, New York Reserve Fund law regulations have commitments that are not being kept by the sponsor. And they also have educated me to the sponsor's failure. My sponsor, Mansfield, has kept 45% of the unsold shares since the initial conversion in 1984. There has been little effort to advertise or sell shares, and there was a requirement of sale of the unsold shares, but it's not being complied with. What's troublesome is that my sponsor is also principal of sponsors of holders of unsold shares of an additional 28 properties in which the principals own in excess of 10% of the shares. I'm concerned with the excess power of the sponsors, holders of unsold share, as it impacts my financial stability. Is not the intent of the offering plan to fully convert the property into a full common interest development? My goal over the last year has been to stimulate discussions which will improve the quality of living, improve regulations and accountability from the holder of unsold shares. It is my feeling that penalty levels or fees should be imposed for non-compliance. I would like to outline these issues as I see it. I took the time to go over the financial records of my sponsor year by year. I will only read salient issues. The financial statements and amendments indicate that there were no budgets provided for the years 2003, 2004, 2005, or 2011. It's questionable whether a timely review of the co-op's available means and options to finance needed capital expenditures was ever conducted. Instead, what they did was increase maintenance charges, including during the mortgage refinancing. There were inconsistencies with the reporting of the 6 mortgage refinancing that was done November 1998, August 12, 2013, 2003, December 10, 2003, May 1st, 2012, October 12, 2012, December 1st, 2014, including I found 2 different monthly payments and a large pre-penalty payment. And we still have fuse boxes. The omitted facts definitely alter the total mix of information made available. My offering plan describes a property containing 360 residential units and 1 garage. My building super cleans the garage. The garage was converted into a business industry, zip car rental. This conversion exposes the building to greater wear and tear, including a reduction of parking spaces for the shareholders. The changes of the garage operation definitely alters the operation income and can cause an increase in maintenance, notwithstanding the fact that it was never disclosed to us that they had this rental business. Another issue that I'm dealing with is my co-op bylaws state that meetings are to be held at an 8-week interval. This has not been scheduled. The only meeting that are held are in December for election of the same board of directors. The holder of unsold share votes his bulk shares, essentially taking the lead position. They fail to allow shareholder regular participation in running the affairs of the cooperative. There is no tenure for this board or requirement to attend meetings. Why not require semi-annual meetings and set a 5-year limitation to board members? Okay, I wanted to share with you some of the gaps that I found in the financial statements. The 23rd Amendment to an offering plan dated April 1st, 2004, reveals a 1.5-year gap in the notice of a prepayment penalty of $283,231. What happened to the funds? It wasn't disclosed. There's no disposition as the balance of the proceeds. The 28th Amendment to the offering plan dated January 29th, 2009, a 5-year gap in notice of a $14,691.50 monthly installment. July 25th, 2011 audit of balance sheets conducted by their CPA, dated for balance sheets of December 31st, 2010 and 2009, reveal 7 years later that there is a balloon payment due in 2014 of $5,657,561, and we're $5,657,561. I mean, when I saw this, and I see that it's 7 years later, and they're just telling us that they had to make this, that there's a balloon payment. What has been gone? Where's the money? How did the proceeds? I don't know. Second, the 32nd Amendment to the Co-op Plan dated December 6, 2012, has 2 loans. One loan, they say, of the unsold shares pledged to Sovereign Bank to secure a loan in the reduced principal amount of $2.5 million. Another loan, 5 months earlier, May 1st, 2012, where they refinance the encumbering premises and identify a new bank called New York Commercial. Okay? And there were no disclosures to this loan modification, and this dates back a year. Okay. Another mortgage refinance I found at May 1st, 2012, but it was reported on their 34th Amendment to the offering plan dated December 10th, 2014. And once again, 2 years later, they're notifying us that they had to make a prepayment penalty of $29,158. Okay? I understand that. It wasn't disclosed to me before. Now, attached to the same amendment is their CPA audit of balance sheets of December 31st, 2013 and 2012. And there is an inconsistency of the monthly payments. It was initially reported the monthly payments were $22,298. Well, in 2014, now they're reporting the monthly payments are $22,344. Now, come on, it's just $45 more a month, $540 a year. But times 3 years, I mean, every little bit helps for me, and especially in fact that the original windows around the building were just changed in 2015, 65 years later. Now, how much money could they have saved if they replaced them in a timely manner? They could have saved on heat. They could have saved, okay. Well, another issue which I found, the sponsors' reserve funds fell below the $100,000 requirement in the years 2008 and 2009. There was no disclosure regarding the sponsor's ability to fund capital items. There's been no reporting of all deposits into and withdrawal from the reserve fund. In addition to, I found that they closed out accounts. And the failure to disclose restriction and use of the reserve funds definitely violates the reserve fund law. The law is also silent as to ongoing offering plan conversions. What happens after the initial conversion with reserve funds? I didn't find anything on that. That's it. That's it. My last item is about the full life of the boiler, burner, and elevators, leading to a poor risk assessment of a 50-year-old building. Once again, increases the cost of replacement, potentially can bankrupt the property. Okay, and there's liens and violations, judgment, litigations, the J51 applications that have not been disclosed. So where's the money going? I don't know.
Thank you. Thank you very, very much.
You're welcome.
Thank you. We are coming down to the end. We're supposed to end at 7, but we're still going to try and fit in as much as possible. Adele Niederman, President.